Start. The principal controversy raised in the petition pertains to the effect of non-compliance of the requirement of 6 months prior notice contemplated under the first proviso to section 21 subsection 1 subsection A of UP Act number 13 of 1972, and the question as to whether such objection stood waived on account of the conduct of the petitioner tenant. A careful reading of the statutory provision indicates that while the substantive part of section 21 subsection 1 subsection A confers a right upon the landlord to seek release of the tenanted premises on the ground of bona fide requirement, the proviso engrafts certain restrictions in cases where the premises was already under tenancy prior to its purchase by the landlord. The proviso contemplates two distinct conditions. Firstly, a period of 3 years must elapse from the date of purchase of the premises by the landlord. Secondly, the tenant must be given a notice of not less than 6 months before institution of the application. The legislative intent behind incorporation of the proviso appears to be to afford protection to an existing tenant against immediate proceedings for eviction at the instance of a subsequent purchaser, and to provide reasonable time to the tenant before such proceedings are initiated. At the same time, the language employed in the proviso assumes significance. The legislature has consciously used the expression "no application shall be entertained" while prescribing the period of 3 years, whereas in relation to notice it has provided that the landlord has given a notice not less than 6 months before such application. The use of different phraseology in the same proviso cannot be regarded as accidental and must be assigned its due meaning. The expression entertained ordinarily refers to consideration of or adjudication of a matter by the authority, whereas the latter part of the proviso especially regulates the stage prior to institution of proceedings by requiring service of notice before filing of the application. The statutory scheme therefore distinguishes between the stage of institution of proceedings and the stage of consideration of the application on merits. The requirement of 6 months notice, though couched in mandatory language and linked with institution of proceedings, is intended to secure a protective opportunity to the tenant before initiation of release proceedings. The protection contemplated by the proviso is initially personal to the tenant and procedural in character. The provision does not affect the inherent competence or jurisdiction of the authority to adjudicate the matter, nor does it involve any element of public duty or public interest. Rather, it confers a statutory procedural safeguard capable of being availed of, waived, or relinquished by the tenant for whose benefit it has been enacted. Since the protection contemplated under the proviso is enacted for the benefit of the sitting tenant, the same is capable of waiver. Consequently, where the tenant, despite knowledge of the alleged defect, does not raise timely objection regarding notice and instead contests the matter on merits, such conduct may amount to acquiescence and relinquishment of the procedural protection available under the proviso. Stop.